Good, thank you. So good morning to Senate Health and Welfare Committee. It's Tuesday, February 13th, 10 a.m. We're going to start in our agenda today with a look at S-192. And Ms. McClendon, if you could join us at the table. So we're going to do a walkthrough of the bill, and Chair Lyons' expectation is that we start asking clarification questions now, so we can get closer to a vote on the bill. But Katie, if you could introduce yourself and then begin to walk us through S-192, an act related to forensic facility admissions criteria and processes.
Sure. Katie McClendon, Office of Legislative Counsel. I've just pulled up our most recent draft, which is 6.1.
Thank you for not having another draft.
Yeah. I have my own draft 7.1. That's just mine
I'm
right
just
now.
waiting to.
Where I'm keeping track of the changes you've made decisions on. Okay, so it sounds like you'd like me just to sort of march through the bill high level, and if there are questions, we'll pause.
Senator Lyons is temporarily away. She'll be back in a few minutes, but she wanted to start the process section by section, kind of detailed to kind of like a last, very general, detailed approach to the bill.
Okay, great. So the first section is the purpose and legislative intent. We have language that it's the intent to enable the two commissioners to seek treatment and programming for certain individuals in a forensic facility, as anticipated by the passage of last year's bill. It's the intent of the General Assembly that the initial facility be authorized and operational beginning on July 1/24 in a 9-bed wing of the current Vermont Psychiatric Care Hospital. Last time when we met, you made the decision to change that date to 2025 and to end the sentence after 2025. So the language in the 9-bed wing of the current Vermont Psychiatric Care Hospital will be removed in draft 7.1.
Okay. If I might just request that after every section you just pause, because I might have questions.
Sure.
And this one, I did note that, so glad to hear that. And then certain individuals in a forensic facility.
Mm-hmm.
I wrote, I was thinking that's vague, but maybe that's okay to be vague. I don't know.
I mean, I guess what I was trying to avoid is duplicating the admission criteria in two places. We could, that's a policy decision if you want to spell it out again here. But I was, certain as to sort of narrow the realm of who could potentially be eligible and indicate that we're looking at a particular population, but there could be other choices made there.
Okay. I think I'm okay with it. I was just wondering if we needed to be more specific, but if you think the specificity that comes after is sufficient, then.
I guess I do, particularly because this is sort of our purpose language, but I'm also, I don't have any concerns if you want to be very detailed there. We could.
You want to just strike certain?
Well, I think certain is helpful in terms of it doesn't mean anybody would go to the forensic facility, only certain people would, but I was just wondering if we might want to add something like certain individuals with mental health or intellectual disabilities, but maybe that's too specific.
We could, it just becomes longer than that because then it's also the criminally justice involved.
Right, exactly. There are lots of
explainers. Yeah, I don't know that there's like an easy phrase, but we could start with, a diagnosis if that's what you want, just mental illness or, intellectual disability. Or you could think about it.
I'll think about it.
Okay.
Maybe vagueness is fine.
Okay. Okay. So next is section 2, and we're adding language here that establishes the Human Services Community Safety Panel. So our first sentence is that this is being created within AHS. The panel is to be designated as the entity responsible for assessing the potential placement of individuals at a forensic facility for individuals who present a significant risk of danger if not held in a secure setting, and are found not competent to stand trial for an alleged, I cleaned that up in the next draft, we have too many verbs, but not competent to stand trial for a crime with which there's no right to bail, or they were charged with a crime for which bail is not available and adjudicated not guilty by reason of insanity. And then on line 2, we have that cross-reference, 13 VSA 4821. So that's referring to this process by which the court is identifying and having a hearing on somebody's competency.
Okay. So my questions here, do you mind, Senator, if I just, okay.
Please.
The title of this panel, the Community Safety Panel, I was just wondering, because it seems like they're dual purpose, like there's community safety and like appropriate care. So it's not just about making sure the community is safe, it's also making sure that that people are
Receiving the right treatment.
Yeah.
Human Services Community Care and Safety Panel, or Treatment and Safety Panel.
I don't know. Does anyone else have a concern about this, or is it just, I was just trying to get the right title for it because it seemed too much on one side by calling it community safety because it's sort of dual purpose.
I don't have an opinion. I would recommend we flag it, and then when the chair returns, we'll touch back at that.
Okay.
But I understand.
And then I went through this draft last night. It took me a lot of chocolate chips to get through it. On the next page, on top of page 2, on line 3, significant risk of danger. I'm wondering if we need to add to self and others, like danger of what?
Yeah,
But
I
again,
would
I
agree.
mean, you think that's good?
Self and others, or self or others, or self?
Self
And
or others,
yeah.
yeah, or probably.
Okay. I will make that change. Okay. Should I keep moving?
Yeah.
Okay. Okay.
Excuse me.
Yeah, no problem. Subsection B discusses who the members of the panel are. So we have the Secretary of Human Services, the Commissioner of Mental Health, the Commissioner of Jail, and the Commissioner of Corrections. The panel is to have the technical, legal, fiscal, and administrative support of AHS and the 3 departments. As used in this section, forensic facility has the same meaning as in 1871-01, so we have the definition elsewhere in this bill. And we're cross-referencing in every title to the same definition, so it should be consistent throughout.
Do we want to have a member on the panel who's not part of the administration?
Yeah, I was thinking that as well. But I was trying to figure out who that would be without making the panel like enormous, because I think it should be a small group, but also like an ombuds person. There's a relevant ombuds person.
There is, but I'm not sure. It's sort of siloed.
Yeah, exactly.
So we have Disability Rights Vermont. They are the federally appointed people for individuals with mental illness. I wonder if the Developmental Disabilities Council is the same. So I'm not sure. I'll have to find out.
I mean, yeah, I think what we could have an or, so that if it's a mental health case, then that would be that ombuds person, and if it's a developmental disability or intellectual disability, it's that person. I'm not sure how to draft that, but and then that would make it so it's 5 people. And I guess if it's somebody who has both, then it would be both ombuds
Yeah.
persons.
Right.
Is that
Okay.
possible to draft that?
I will, yes, I will figure it out.
You are a magician, so you will figure.
Well, I just have one question on, should it be both? Because we heard testimony from the two departments, that there's usually a lead.
Lead department,
yeah.
yeah. So whoever is the lead department, that would
be the, okay,
ombuds person,
Okay.
that would
okay.
be the person.
I want, are we allowed to comment?
Sure.
Okay, sorry, for the record, Karen Barber, General Counsel, Department of Mental Health. So I hear the concern, but I thought maybe it might be helpful to kind of talk about the process because I'm not sure what an ombudsman would bring to the process. So just as a reminder, like this is kind of a conversation amongst internal folks because ultimately, right, it's up to the custodial commissioner to make a recommendation to the court. So the panel is kind of looking at things, but ultimately the custodial commissioner alone makes the decision. And then the person has their own attorney. And so in the courtroom, there already is an attorney that will be advocating for the person. So I'm not sure what more an ombudsman would add because they're already represented by counsel.
I don't know that that's clear. I mean, in the bill, that when they talk about the rights of the person, it doesn't really specify that they're gonna have legal counsel. Is it just assumed that they always will, or?
We're not really touching the statutes that are addressing legal counsel. So there's already a process in place
Okay.
for commitment, and we're sort of adding a layer of a new facility that persons can go to. If that makes sense.
Good.
Okay, yeah, that's why, I mean, I phrased it as a question. I wasn't sure if it was,
Well, Karen,
necessary,
I think it's because they're all such internal commissioners, I think having an outside perspective as a fifth member of the panel could be helpful. Because it can get a little, what's the word? Just too inside focused.
I think that is the role of the attorney though, and the attorney is in a much better position to kind of make the arguments and understand whether or not the person meets criteria or not, because ultimately they're going to be the ones talking to the judge about it. Right, because the panel is only making a recommendation, right? The panel is not making a decision. They're making a recommendation that the commissioner can or cannot accept, right? Ultimately, it's the custodial commissioner that makes the decision and then asks the court. So if the custodial commissioner says, yes, I do think this is appropriate, then the commissioner has the obligation and the burden to go to the court and say, I believe this is the least restrictive. And then the person has their own attorney who advocates for them. And the attorney can say, yes, we agree, or no, we don't agree that the state has met the burden. And then there can be a contested hearing. But the attorney is the one that's going to be making those arguments.
Is it an appointed attorney, or, I mean, if
Yes.
the individual can't afford counsel, he's gonna get somebody from legal aid, or?
Yep. So there's the Mental Health Law Project through Legal Aid, which is who represents everyone who comes in on the DMH side, and then they have a similar project. I don't know the exact name of it for folks coming in on the Dale side, but Stuart would know the name of that project.
I guess then sorry.
Because I agree with you. I think that, thinking right now as somebody that might be in that situation, and I wouldn't be able to afford an attorney or designate it before I'm in that mental condition. I'd like to be able to have the best attorney there representing me, not necessarily somebody from legal aid that doesn't know me or.
Well, the ombuds person wouldn't be their attorney.
Right.
I'm just talking about for the panel.
Okay.
And I will say that the legal aid attorneys are good attorneys.
Yeah,
They're
I'm
really
not
good
saying they're
attorneys.
not, I'm just saying that.
But I think having an outside perspective, and I think, Karen, if you're arguing that it doesn't really matter what this panel says, that sort of sounds like what you're saying, then why do we have the panel? I don't see the point of the panel if the commissioner is just going to do what the commissioner is going to do. And so maybe we just get rid of the panel.
So I think the point of the panel was for AHS internally to think about what resources it could bring to the table, right? So is it bringing the folks together? Is the forensic facility the best available option? Or are there other options within AHS that AHS could work together on to do a different, less restrictive placement, right? So it is kind of an internal discussion about what the agency can bring to the table and what makes sense. And so I think that was the goal of bringing the groups together. That's different than whether or not the person kind of meets criteria, and the role of the attorney is to make that argument, right? And the reason it's legal aid is because they specialize in this, right? They know the system intimately, frankly, more than the ombudsman, because they're the ones that are representing everyone coming through the system. So they're very well aware of how the system works and what the standards are. And so that's why, I think that they're being represented adequately by legal aid already.
Yeah, I still think we should have an ombudsperson because I think it's too internal. And you work for AHS, so of course you're gonna wanna have just an AHS conversation, but I think having the outside perspective is helpful.
Can we get a quick testimony from legal aid, from someone like Mike Fisher or,
From the ombudsperson, we could.
okay, or those folks, yeah.
So it's disability rights Vermont for mental illness, and I am I'm assuming it's the Developmental Disability Council. Stuart's shaking his head, so.
No, actually, if we're looking at the protection and advocacy organization, for all individuals, Disability Rights Vermont does represent both individuals with mental illness and intellectual disabilities. The DD Council is a different organization with different federal statutory authority, but if you're looking at the equivalent protection and advocacy organization, it would be DRVT for both populations. But I did just want to echo what Karen said, and also to add that in addition to this being an internal process so that the agency can determine what it believes, not what it concludes, but what it believes is the best and least restrictive environment for that particular individual, so we can make a recommendation. The agency and the commissioners do have the opportunity and likely will consult with its own clinical expertise to reach that. So it's not as if it's exclusively an internal decision. There are clinical determinations that are made so that the agency can make the best recommendation to the court, and then the court has its process, and as Karen said, through which the individual has their attorney who's making those arguments that they don't believe, for example, that is the least restrictive, or their client should not be put into a forensic facility, but could be served in a community, for example. So,
I think we should hear from disability rights and see if what they think. Yeah.
Good. Thank you.
Okay.
Katie?
Okay, section 3. This is our section 4821 in Title 13. The existing language is the process by which there's a hearing on whether a person is incompetent to stand trial. And then we're adding a new subsection B here that's specific to the Human Services Community Safety Panel. So once a report concerning competency or sanity is completed or disclosed to the opposing party, the panel may conduct a review on its own initiative regarding whether placement of a person who is subject of the report is appropriate in a forensic facility. The review shall inform either of the two commissioners' decision as to whether to seek placement of the person in a forensic facility.
One little note I made on the paragraph above, just line 2, you added the person's attorney, and then I think it should be the person's legal guardian also.
Okay.
Because it just says the legal guardian.
Yeah.
And is that clear that it's the person's legal guardian?
Let me just read it. Sure, let's do that.
So that mentions the attorney. Yeah.
Thank you.
Thank you.
Subdivision B2, if the panel does not initiate its own review, a party to a hearing, meaning a hearing regarding the person's competency to stand trial, may file a written motion to the court requesting that the panel conduct a review within 7 days after receiving a report. Or within 7 days after being adjudicated not guilty by reason of insanity. So this is asking the court to request this review. A motion that is filed pursuant to the last paragraph shall specify that the person who is the subject of the proceedings is charged with a crime for which there is no right to bail pursuant to the 2 sections, and may include a person adjudicated not guilty by reason of insanity, and that the person presents a significant risk of danger to themselves or the public if not held in a secure setting. The court is to rule on the motion within 5 days, and a panel review ordered pursuant to this subdivision 2 is to be completed and submitted to the court at least 3 days prior to a hearing under 4820, meaning a hearing on whether we're going to place somebody in the commitment of the commissioner. Okay, and now subsection C, we're looking at what is the review, what is the content of the review? Why are they doing the review? What are they looking at? So in conducting the review as to whether to seek a placement of a person in a forensic facility, the panel is to consider the following. It's broken into 2 pieces, clinical factors and dangerousness factors. Under clinical factors, that the person is served in the least restrictive setting necessary to meet the needs of the person, and that the person's treatment and programming needs dictate that the treatment or programming be provided at an intensive residential level. Under dangerousness factors, the panel is to look at whether the person has inflicted or attempted to inflict serious bodily injury on another, attempted suicide or serious self-injury, or committed an act that would constitute sexual conduct with a child, or lewd and lascivious conduct with a child, and there is reasonable probability that the conduct will be repeated if admission to a forensic facility is not ordered.
Can I ask about the word dangerousness?
Yes.
That seemed a little awkward to me, but is that, I mean, it's a real word, right? Dangerousness?
It is a real word. I am most definitely open to other suggestions. I think this is a word that came from
Is it already used?
No, I think it came from house language. I think it probably originally came to us as a proposal from the administration when they were proposing the panel.
Mm-hmm.
I'm not certain at this point, but I would, I think another word could be utilized here.
Yeah, I couldn't think of another word, but dangerousness seems a little awkward to me.
What's your other word?
I said I couldn't think of
Oh,
another
couldn't.
word. It sounds like a word that like a, little kid would use when they're trying to figure out how to say something. Oh,
Let me check the thesaurus.
Yeah,
See
go
if I can.
librarian, English teacher.
So I can explain our rationale. And so I wonder if maybe public safety, I think the idea was to say that it's kind of a mix of like clinical and public safety concerns. So I don't know if public safety is a better word, but that's what we were getting at. We wanted to differentiate, right? Because you needed to meet the clinical threshold. And then the idea was also that there would also be another reason why would justify a restrictive setting. If that's helpful context.
I understand why you were doing it. That makes sense to me. I was just, the word dangerousness seems a little funky to me.
Could we just say
Correct,
safety
risk of
factor?
harm or risk of harm factors?
That maybe, yeah, risk of harm or safety. What do you guys think? Risk of harm
Yeah,
or
there
safety?
are no good synonyms.
Do you want to go through all of them and then make a decision?
All the factors?
Yeah.
Sure.
Okay. So we just did A. B, whether the person has threatened to inflict serious bodily injury to the person or others, and there is reasonable probability that the conduct will occur if admission to a forensic facility is not ordered. C, whether the results of any applicable evidence-based violence risk assessment tool indicates that the person's behavior is deemed a significant risk to others. D, the position of the parties in the criminal case as well as that of the victim, and any other factors that the panel determines to be relevant to the assessment of risk.
What does, on line 13, position of the parties to the criminal case, what does that mean?
I would take that to mean what the prosecutor is suggesting, and if the victim has an opinion about the placement of the person in a forensic facility. Well, parties, defense too.
So it's basically the prosecution, the defense, and the victim's advocate. And victim.
Could you say risk of danger factors? Or is that too many words?
I mean, it's your bill, you could say whatever you like. Risk of danger factors.
Or just safety, risk of, or safety,
Safety impact?
or public safety factors. I don't know. But I mean, does public safety include the person themselves? Because are they considered a member of the public?
Well, they're described.
Yeah.
Paragraph A, so it's got to include them.
Or risk factors.
Well, definitely something with risk, because there's risk in almost every element.
Yeah.
I was thinking.
I like risk of harm.
Risk of harm factors.
Yes.
Okay.
All right, sure, let's try that. See if it sits well. Okay.
Okay, any other questions there? Okay, we're on page 6, we're moving along to section 4, and this is the portion of the bill specific to individuals with mental illness. So first we have our definition section, and this is where our definition of forensic facility lives that we keep cross-referencing to. So let's maybe take a look at this. Forensic facility means a residential facility licensed as a therapeutic community residence for an individual initially committed pursuant to 13 VSA 4822 who is in need of further treatment pursuant to this chapter in a secure setting for an extended period of time. So the cross-reference, you'll see we have on line 11, 4822, and on line 14, 4823. One of those sections is specific to competency to stand trial for individuals with mental illness. The other is competency to stand trial for individuals with intellectual disability. So we're just different cross-references, but the same through language of that the person that it would be a secure setting for an extended period of time. And then we have language that a forensic facility shall not be used for any purpose other than the purposes permitted by this part of the Title 18, meaning the mental health part of the bill, or Chapter 206, which cross-references the language in Title 18 on intellectual disability. And as used in this subdivision 31, secure has the same meaning as in 7620, which is where secure describes the secure residential recovery facility. So if you want to look at that language, I'll have to switch screens and pull it up.
My question on this is not actually about this definition. That seems fine, but further in the bill, there's a lot of use of the term order of non-hospitalization. And I was wondering if that is actually defined somewhere.
I believe it is. Oh, I don't know if it's in 7101. I have to pull it up. Do you mind if I stop sharing and switch screens? Yeah.
Your mere presence puts you back in charge. So how about we'll finish up, we're in section 4.
Okay.
Finish up with 4, and we'll go back, just a couple questions. That way,
Okay.
we're all together.
Yep.
Okay, we'll rejoin at section 5.
No, this is where we have our clinical standards of a person in need of treatment. But we don't have a definition of the order,
Okay.
but the context.
It's 18 VSA 7618 is where we talk about an order of non-hospitalization. It's in the judicial proceeding section.
Is there a definition?
If the court finds that treatment other than hospitalization is adequate to meet the treatment needs, the court shall order the person to receive whatever treatment other than hospitalization is appropriate. So it's an order for anything other than hospitalization.
So
Okay.
So it's
I
an
was just wondering-
outpatient order.
Right, I was just wondering if there's some specific definition of what an order of non-hospitalization was, or a process or something, and, I mean, so
No.
it sort of is, but sort of not.
I mean, I don't see, no, there's not a definition as what you're thinking of an order of non-hospitalization means.
Yeah.
It's one of the options that the judge has to, either an order of hospitalization, non-hospitalization, or you can dismiss.
Yeah, because and this comes up because later when the term order of non-hospitalization is used, I have a specific question about it, so
Okay.
I can ask that question then, just, but, okay.
Okay.
All right, Senator Weeks, did you want to catch up? Should we catch up, the chair?
So going back to page 1, line 11, the word certain in certain individuals may be deemed too vague. Although this is in the intent section, does it need to be flushed out a little more? That's the first question.
Okay.
Second page,
The community safety panel, whether that was,
the name of the panel.
yeah, the panel.
You don't like the name of the panel?
Community safety, it seems like it's only one side, it's sort of, there's both community safety factors and then there are treatment factors that they're
Okay.
considering, so. don't know.
Community Services and Safety Panel. Does that make sense?
Human services,
Community Services and Safety Panel. It says Human Services, Community Services. How about Human Services Community Panel?
or how,
Well, let's
human
let it go, but
services,
there's a
treatment
question.
and community safety panel?
Something.
I don't know,
Well, think about it.
yeah,
Okay, next was page 2, line 3. Could be potentially reworded as percent of significant danger of risk. Significant risk of danger to self or others, if not held in a secure setting.
Oh, two self-employed.
So page 2, somewhere around like between line 14 and 15. For the members of the panel to include, the recommendation was made for essentially a non-executive administrative member, someone like an ombudsman from one of the agencies to serve as the non-departmental perspective of.
yeah, so Senator Gulick and I were talking about maybe adding disability rights as a position. Karen and Stuart pushed back on that, so my request was that we have disability rights and to talk to them about that, because this
Well,
seems,
I will
very
say that,
internal.
yeah, this was a discussion during the working group process, and the minute you add one, then you're gonna have to add another. So, I've got it marked.
well,
So
they're
we can
the
have that.
official ombudsperson,
We have an
for
yeah.
both populations, so that would be the sort of
Right.
check on the internal discussion of just commissioners, so.
Okay, next question was, or recommendation was page 3, line 2. to read, the person's legal guardian, as opposed to just the legal guardian, since it says the person's attorney. So
Okay.
inserting.
Person's legal guardian and attorney.
Got it. Okay,
Let's see, page 4, line 21. Instead of the word dangerousness, we were contemplating other alternatives for kind of a chunky word and adding something like, or replacing with something like, risk of harm, including. Anyway, the contention, the discussion came up over the word dangerousness.
It sounded to me like that word, what I envisioned when I read the word was like kids on the playground saying, oh man, Superman, he's got a lot of dangerousness. You know, like
Got it.
something like that. It sounded like a made up word that kids on the playground would make. Sorry, you guys, I know you made up the word or included the word, but it seemed not
Okay.
as specific enough. So risk of harm factors.
Katie, maybe you can help us with some synonym or something, I don't know.
I'm happy to. The committee sort of spent some time talking about this and landed on risk of harm factors.
Yeah.
We also, mentioned maybe safety factors.
Well, our
Safety may sound better than dangerous.
educator, librarian, committee representative, did a synonym check. We didn't find anything.
It's not a good
Good.
one
Did you
word.
find one?
No.
Oh, okay, well, we'll work on it then. Got it.
Okay,
Okay.
the last bit, before you join, page 5, line 13, and I'm not sure where we really settled on this, but the position of the parties was a question.
Oh, it was just a question
Okay,
about
so
who
you're
that was.
satisfied
Yeah,
with-
yeah.
You got the
Explained
answer?
it. Yeah.
Okay,
So that leads us back to page 6, line 20.
there we go, okay. Let's go ahead then,
Keep moving?
please, yeah.
Sure. Okay, the next section has to do with the application for involuntary treatment. So this is sort of the initial application that the commissioner or another interested party files to have a person committed to the custody of the commissioner. So there's a whole process outlined here what the petition contains. We have in subsection F, some language, striking, using gender neutral language instead of he or she for examining physician. And then in subsection G, we have a new section that if the commissioner seeks to have a person receive treatment in a forensic facility pursuant to an order of non-hospitalization, the application for an order authorizing treatment shall expressly state that such treatment is being sought. The application shall contain, in addition to the statements required by this section, a statement setting forth the reasons for the commissioner's determination that clinically appropriate treatment for the person's condition can be provided safely only in a forensic facility, including the recommendation of the panel.
So this is where the term order of non-hospitalization is in here. And I said, first of all here, isn't the forensic facility proposed to actually be in a hospital?
It's not licensed as a hospital. It's licensed as a therapeutic community residence. So it would be,
It's a non-hospital
it would
place.
sort of be that unit, if they were to use that facility, would sort of be delicensed as a hospital and licensed as a therapeutic community
Okay.
residence.
So that would still count as non-hospitalization.
It would. For example, secure residential recovery facility is a therapeutic community residence, and it's an order of non-hospitalization.
Okay. And then on the previous page 7, this is existing law, but the cross references on line 5, paragraph C, 7508 and 7620 are what specifically are those?
I don't have them at my fingertips. They're in, let me pull them up. They're in the mental health part 8 of Title 18. And I think it's probably process.
Okay.
7508 admission
It is
procedures.
process.
So 7508, emergency exam and second certification. So those, that section governs after a person is initially taken to a hospital, there's an exam to decide if the person is meeting criteria before an application is even filed, to have them committed to the custody of the commissioner. So that's what 7508 is that exam process.
Okay.
And 7620 was the other one.
Mm-hmm.
7620 is an application for continued treatment.
So before all of this began, mental health patients were being, or involved in the criminal justice system were being treated one way with a set process. And then a question arose, and we were part of that questioning last year about how do we treat people with intellectual disabilities who are involved in the criminal justice system. So this is part of this. Part of what we're doing is trying to align those two in some way, but not completely.
Alignment. We're trying.
Can I just try this again? So this is sort of saying the application is filed as an initial order or as a continued order.
Okay.
Yeah.
Okay. That makes sense. But, and then we go down through G. There's so many different like subsections of things. It's like G does not necessarily, the new language in G does not necessarily flow directly from C, meaning that this is about an initial recommendation to go to a forensic facility, not a continued recommendation.
Correct.
Okay.
So this whole section is entitled, it's the application for involuntary treatment. So this is the initial, this whole section is on the initial application for an initial placement in the commissioner's custody.
Oh, okay, but I thought you said 7620 was continued.
It does, it's a reference to that. So I think, let's see, because this is talking about where the application is filed, it's just adding a cross-reference. So this subsection C is saying that if the application is filed under one of these two provisions, that shall be in the family division in which the hospital is located. In other cases, that shall be filed in the unit which the proposed patient resides. If in the case of a non-resident, so this is talking about the venue of the proceeding, and by having 7620 here, saying that the process is the same for application for continued treatment.
Okay.
I lost my document here.
Sorry.
No, it's okay.
I think we're going to
Section 6, yeah.
Okay.
And this is the one that I had a lot of confusion on, and I read it like 20 times.
Okay.
Before.
So section 6, this is our section on a hearing on the application for involuntary treatment. So again, the application for involuntary treatment is the initial application that generally the commissioner, but it says interested party, could make to have a person initially committed to the care of the custody, care of the commissioner of mental health. So we have a lot of existing language here about the hearing. The new language begins in subdivision 3. The applicant or person for whom an order of non-hospitalization at a forensic facility is sought may file a motion to expedite the hearing. The motion shall be supported by an affidavit. And then it lists the conditions in which a court can expedite. So the first paragraph beginning on line 9 is a shall. The court has to grant in order to expedite in this condition. Then the language on beginning on line 13 is a may. The court could decide to expedite in this situation. And this, I want to make sure what I'm saying is accurate. This tracks, yes. This tracks the language in subdivision A2 about expediting a hearing.
Sure. You mean 2A?
A2A.
A2A, yeah. So that was my question. I reread A2A
Mhm.
and is this A3A?
This is A3A.
Yeah, so first of all, I had to like track all the
Yeah.
letter numbers. There are a lot of them in here. The language is the same. The
Mhm.
first one is for applicant for a person in need of treatment, right?
Yes.
And the second is an application for non-hospitalization at a forensic facility.
Yes, because generally, let me double check. Person in need of treatment. So, I'm gonna look at this a little bit more closely. A3A is dealing specifically with an application, for when placement is sought at a forensic facility.
Mhm.
But I do take your point that I'm almost wondering if you're wondering if the lead-in language is A2A should be specific to orders of hospitalization. Is that what you're wondering? Because why else would we need a separate section specific to a forensic facility?
Yeah, I was wondering why it was repeated and
Yep.
it
I
didn't track
I can
for
talk about
me.
that if you want. It's
Yeah,
because we need an order to do medications. And so currently the idea is that someone could go directly to the forensic facility and not through a hospital. So we need a mechanism to use the medication statutes. And so there needs to be an actual order. And so they're a little bit out of order, right? Because we're doing this before we get to the medication statutes. But what this is allowing us to do is to get an order so that then we can apply for involuntary medications. Because it's a two-step process.
Yes, because the medication language specific to forensic facility drafted in this bill, tracks if somebody was eligible for an expedited hearing. But I think the question is, in A2A, is this specific to people who are, for whom the commissioner is seeking an order of hospitalization versus non-hospitalization? Would there ever be, would the commissioner ever seek an expedited hearing when seeking an order of non-hospitalization under A2A?
No, that is specific to people who are being hospitalized, because right now, if someone's at River Valley or at a secure residential, they have to be coming off an ACT. And so I think it's number 6 or 7 that deals with them. And so this is just for the hospitalization.
So should A2A be amended to specify that this is specific to people in need of hospitalization? Because if you did add that specificity, then having a separate language for A3A for the forensic facility makes more sense.
Yeah. I agree.
is this something that we can resolve?
I'd need to look at it, I guess, a little closer.
Why don't we say this is an important question? I think it's a good question. Why don't we give the homework assignment? And we can all go through it, but I think Katie and Karen, you're probably the best ones to bring back that recommendation based on how it fits into other statute. I was just looking at the statutes again.
Okay,
Yeah,
Okay.
I'll take another
Let's do
look at
that.
thank
Yeah.
you.
Yeah.
It was
I-
very confusing to
I
me
hear the
as to
question.
why it was necessary. Okay.
Yeah, or why we don't just
Make sure it's
Combine
clear.
them.
combine it and
Yeah.
say own it. But then we have this B that, oh no. Okay, B is the timeline. If the court grants the motion for an expedited hearing, the hearing shall be held within 3 days from the date of the order for the expedited hearing, which is different from the 10 days
Yep.
up above.
Yep.
And the court may grant an extension of not more than 5 days. To allow the psychiatric exam in accordance with 7614.
Yeah.
Okay, Yes, I will look at this and see if there's a way to combine those two pieces if we're using identical language and it's, but for the different timeline.
Okay.
Okay,
And then the next section uses non-hospitalization again. Order,
Four.
non-hospitalization. Oh, no, section 7, sorry.
okay,
Are we done, we're done with 6 then? I think we've identified the issue there, so that's good. Let's go to page 11.
okay, yes, because now we're switching sections, so this, I'm not sure if I'm answering your question, but there is a section on an order for hospitalization, and now this is a separate order for non-hospitalization, so this is the ONH, okay. I just wanted to make sure we're on the same page.
ONH.
ONH, yeah. So we have our existing language, if the court finds that treatment other than hospitalization is adequate to meet the person's needs, the court orders the person to an order of ONH for a period of 90 days. So that's existing. And then you're adding, this bill is proposing language in subdivision A2, that if the commissioner determines that treatment at a forensic facility is appropriate, and the court finds that treatment at a forensic facility is the least restrictive setting adequate to meet the person's needs, the court shall order the person to receive treatment there for a period of 90 days, and the court may at any time on its own motion or a motion of an interested party review the need for treatment at the forensic facility.
And that at any time is within the 90 days, at any time within the 90
Yes.
days. Okay. And this is the initial 90 days.
Yes,
Okay.
this is the initial order. Okay, should I keep going?
Yep.
Okay. Section 8 is the application for continued treatment. So this is our next step. The person has had an initial order for up to 90 days and the commissioner sees that the person likely needs continued treatment. So they file a petition with the court or an application, the ACT with the court, to ask the court to find that the person continues to meet the clinical standard defined for a person in need of continued treatment and to continue holding the person in the commissioner's custody. So that is what is 7620 is. This subsection D, we don't have a lot of language because you've already created a process when the secure residential recovery facility was created that we're just sort of building on. We're borrowing, that was already an order of non-hospitalization, so we're just building on that structure. So if the commissioner seeks to have a patient receive further treatment at a forensic facility or a secure residential recovery facility, the application for an order authorizing continued treatment shall expressly state that such treatment is being sought. The application is to contain, in addition to the statements required above, and B, a statement setting forth the commissioner's determination that clinically appropriate treatment for the patient's condition can be provided safely only in a secure residential recovery facility or forensic facility as appropriate. And then you have a new sentence specific to the forensic facility. An application for continued treatment in a forensic facility shall include the recommendation of the Human Services Community Safety Panel.
And I think this, we may have already talked about, but I noted it again, that this is about continued treatment and the panel's recommendation was on initial treatment.
Yes.
So the question was, do we want to have a new recommendation from the panel or does it matter anymore? Like their initial recommendation is maybe not still relevant.
It might be relevant.
It might be relevant,
Yeah.
but it might not be. So that's the thing, like.
Well, I think that's a question that we can't answer unless we hear from, I think we should hear from the administration on that.
Well, I mean, if they did an initial,
They did an initial assessment.
recommendation like 90 days ago.
Right. Do they need another one?
Is it, yeah, they might need another one because the person's
Oh.
received treatment. Maybe the person is, things have changed during the treatment. And will the panel know that and have that information about, and unless we ask them to do a revised
Exactly.
assessment.
That's why it's here. So you know, I would think I think we leave it in for now, but if you want to take it out.
Well, what I
Are
was
we,
thinking,
are we,
go ahead.
sorry, are we reading the recommendation as the original recommendation or a new recommendation? It's not
Exactly.
specified.
Oh,
That's
that
exactly
was
it.
not the question I heard. Thank you.
Yeah, well, that's what I was trying to ask, is it like, do we want to say a revised recommendation of the Human
Right.
Services Panel?
Instead of the original.
I wonder if may I speak to that?
Yeah, please go ahead. This is an important time for us to just, you know, we accept some conversation. Go ahead, please,
Thank you.
Karen.
So let me just explain first as background how it works now, right? If you're in the secure residential. So, basically after the criminal court order is up, it needs to go to family court, right? After those 90 days, it needs to switch to family court. So if the burden is on the state to meet its burden, right? And so the DMH or Dale is making a decision about whether or not the person meets clinical need to then apply to the court to do it. So there is already an analysis going on, right? The commissioner knows how the person is doing, they're getting clinical updates, and then they're deciding whether or not they still need that restrictive level of care or whether or not they can be moved down to a lower level of care. 90 days is not a lot of time. And so I think that it makes more sense to just rely on the clinical process that already exists, which is that the state must prove its burden. And again, the person will have their own attorney. So if the person doesn't agree that they continue to meet this threshold, their attorney can go into court and argue that they don't meet it. And it's the state's obligation to show they meet the burden. But there is already an analysis going on. We couldn't just file to continue the order unless there was a clinical justification for it and the person met criteria. So that is already happening. And the idea is that this would just mimic that process that already occurs.
So then it wouldn't make sense to do a new evaluation, by the panel, but it would make sense to have the panel's initial recommendation for comparative purposes.
Well, I guess
that
what Karen just described, and she described a similar thing when you were not in the room, again, makes me wonder if we even need this panel, because there's this other process. The commissioner makes the recommendation anyway.
Are you talking about whether we need the panel here?
At all, period.
Okay, so what I'm gonna suggest is that it might be helpful to leave it in for now, and then let's have that larger discussion after we've been through this. I think that's a question, because there's a lot of pros and cons to that outside of this committee. And
well, even if we're gonna have the panel, having it broader than just a bunch of commissioners.
okay, that's the question that you raised earlier. So,
right, exactly.
Yeah, I get it.
But the way that Karen is describing the process now and also earlier, the commissioner is the one that's ultimately making a recommendation, and the burden of proof is on the state. And so it seems like the panel is kind of superfluous.
Can I make a suggestion? Either way, can we add original recommendation just for clarity? Would you guys be okay
Let's
with
do
that?
that here. That's a good
So
idea.
it's
Do
not
that.
clear.
It's not clear. It's not clear. I mean, I guess I would rather have it be a revised recommendation. If the time has passed and things have changed, then.
Let's hold that discussion. So it's a question of whether it's revised or original, and then questions about whether or not the panel is the panel or an expanded panel. And then, and we've heard that 90 days isn't a whole lot of time for folks to receive treatment and to see change. So that's another, all of this goes together. It's not.
In a vacuum.
So we've identified places that link in with other concerns. Okay, and here's what I'm gonna say right now. We're gonna continue to go through this bill. So for folks who are here for 197, the bill that we will probably put off a little bit is 187. So 197 we'll try to get to today. That's all I'm gonna say, but I would suggest, you might wanna walk out the door and come back in. Yeah, take a little walk. Yeah. Okay, go ahead.
Okay. I just want to bring this to your attention because I referenced it before. In the definition of forensic facility, it says, secure as used in this section will have the same meaning as in another section. So this is the definition of secure that is relevant to the definition of forensic facility. So when describing a residential facility means that the residents can be physically prevented from leaving the facility by means of locking devices or other mechanical or physical mechanisms. So that's what that cross-referenced. Okay. Now we are on section 9. We come to the hearing on the application for continued treatment. Again, this structure was already in place because of the previously created secure residential recovery facility. So we're just piggybacking in this section on language that was created a few years ago. If the court finds that a patient is a patient in need of further treatment, does not require hospitalization, it shall order non-hospitalization for up to 1 year. If the treatment plan proposed by the commissioner for a patient in need of further treatment includes admission to a secure residential recovery facility or a forensic facility, the court may at any time on its own motion or a motion of an interested party review the need for treatment at either the secure residential recovery or forensic facility as applicable.
So then the question, is we're using the commissioner throughout, and there are times when it's Dale and times when it's DMH.
No, this only applies to DMH.
That's what I'm saying. That's where I'm getting to.
Okay.
So it only applies to DMH. So I'm wondering if there's a way that we could clue that in for us during this process. Would it be redundant? It would be redundant once it's in statute.
Yes.
But it's right here. Let's be clear as we're going through that we're talking about Department of Mental Health.
Yes.
Period.
The whole first half of the
all
bill
it's gonna say.
is Department of Mental Health.
Right.
And I have reader headings, but now we're so far past it. But on page 6,
Yeah.
we're talking about admission to a forensic facility for a person in need of treatment or continued treatment. So those are persons meeting the mental health criteria. And then we'll come to reader headings to let us know when we're switching to people who are in need of care, custody, and rehabilitation.
So far, what we've been talking about is DMH.
Yes.
And that, so just to make the note of that in our heads. Okay. Okay.
So that brings us to section 10, which is the application for involuntary medication.
Can I ask a question on page 15, which is not new language? You just included this for context. But the 5A, B, and C.
Hold on.
At the bottom of page 15, line 16 through 20.
Yeah.
This is, has an application for involuntary treatment pending. And then waives a right to a hearing and then agrees to proceed with involuntary medication without a ruling?
Yeah, so let's take a step backwards first. So each of these subdivisions indicated by, there's a number to start, so 1 through I think 7 now.
Yep.
These are all instances in which the commissioner can apply for involuntary medication. Yes, one of those situations, the application for involuntary treatment is pending. So that is the initial application. The person waives the right to a hearing on the application for involuntary treatment until a later date, but agrees to proceed with involuntary medication hearing without a ruling on whether the person is a person in need of treatment.
My question here was, does this actually happen? Because this is like somebody's, there's involuntary treatment. Why would anybody who's seeking, for whom the court is seeking or the commissioner is seeking involuntary treatment, why would somebody waive their right to an hearing on the application? Or why would they proceed without a ruling? Like, this doesn't seem like somebody would do this.
Can I interject here? That's a really good question, and it's one that we grappled with over, because we did take testimony on this, I can't remember when it was,
This
a
was
long time ago.
language that I remember Representative Donahue
Yes.
wanted to see added when we took this up, I wanna say 6 years ago or 7
Yeah,
years
it's a
ago,
long time
but,
ago. Like, it
I'm not recalling the,
took a lot of testimony.
the rationale behind adding this.
Okay.
And I don't know how often.
I can speak to it if you want. It's because there are legal implications, right? So if you are actually found, if there's an order of hospitalization, it could impact your gun rights, it could impact your security clearances. So there are real legal ramifications for being under an order. And so if someone gets meds without the order and never gets to the order, then it wouldn't trigger the provisions that would say bar them from owning a gun or having to having it flag on their security checks. Does that make sense?
So in
Because
other words,
normally there has to be an order before we can get meds.
Thank you.
so in other words, this allows a person to be voluntarily treated, but involuntary medication. So
There's,
so never
Take
going
some
through a
out of-
commitment proceeding to be in the custody of the Commissioner of Mental Health, but is subjecting themselves to an involuntary medication proceeding. Because right now, people can receive voluntary treatment in
Right.
the hospital, so it's,
so this is basically saying that somebody can voluntarily receive involuntary treatment.
well,
It maintains
voluntarily
patient
receive
autonomy and
treatment.
decision-making.
Well, is it just so that they can then later pass the background check to buy a firearm?
No, no, it's bigger than that. This is an issue, if we begin this issue, it's a whole nother bill.
Well, I just had questions that this didn't make sense to me, and as
I
we're
get
going
it.
through the bill, like, if there's
I get
a
it.
provision that doesn't make sense, and,
So-
and,
And it's not just about security clearance. It's, I think, if we want to, well, let's move past this one for now, and then if, we'll try to get some clarity on what that means. I agree with you, I want to know, but we can't go back and redo every piece of statute, and I understand your conundrum, because I have been there, so. Maybe, Katie, you could give us a recall what happened when they went through this previously, and I'll go back and look and see if I can find some of the testimony that would help.
Yeah, I'd have to look at my
clarify.
notes at this
I know
point, but
it's back there, and I forget what year it was, but that would help Senator Hardy and others, I think,
okay,
help us all.
yeah, I have to
Yeah.
dig through my files. Okay, I'm gonna keep moving for the time being. So this adds a new avenue, a new option through which the Commissioner of Mental Health can seek to have involuntary medication for a person. So this stipulates that the Commissioner can seek involuntary medication. The person has been placed under an order of non-hospitalization in a forensic facility, or has the application for involuntary treatment at a forensic facility pending, for which the court has granted a motion to expedite. So remember when we were looking at the expedite language and Karen was saying it's about the option to involuntarily medicate, this is where that becomes relevant. So the person is either already on an ONH at the forensic facility, or their application, their initial application is pending, and the court has said, yes, you've met this criteria, I think we should expedite the hearing. And this says, regardless of whether the person has previously been under an order of hospitalization. So a person doesn't need to be hospitalized first in order to the Commissioner to be able to submit an application for involuntary medication. This could be their first time in commitment and order of non-hospitalization, and under this, the Commissioner could seek involuntary medication. Okay.
The next paragraph, 7,
Yes.
I know you're just changing non-gendered language, but, Didn't we
Oh,
add
psychiatrist.
psychologists?
Let me think about this.
What is the question on?
Psychologist.
Psychologists.
Oh, right.
Good
The-
catch.
Yeah, you're right. Is that?
You know, hold on, this is something I have to ask Karen actually, because the psychologist is for the competent, right?
Right,
It's not-
this is different. This is not about competency or sanity. This is about their treatment needs. And a psychologist isn't going to be prescribing medications, their psychiatrist will be.
Okay.
Thank you.
Are there any other Are there any other questions on involuntary medication under this section? Okay. So that brings us to the end of the mental health sections of the bill.
Yeah.
Okay, are you ready? Do you want to pause? Do you want? should we keep
Let me
going?
ask the committee, would you like to pause here or keep going? Because we can push on with this bill, and then come back to 197. And
I'd like to continue with this bill.
I'd
please. Yeah.
like to continue. I think our heads are here. Let's keep going.
Okay, great. So we're transitioning to persons in need of custody care and rehabilitation or continued custody care and rehabilitation, a different standard than person in need of treatment.
So, yeah, but contextually, it's a person with an intellectual disability. I have a question regarding the 90 days
Mm-hmm.
rather than indefinite or limited.
Mhm.
So my question is, and understanding, we received some information from Dale that's posted on our webpage about 90 days being a very short time, and people with an intellectual disability may not benefit from the treatment, may not be able to change their capacity. So my question was for Katie,
Mhm.
if we took out indefinite or limited, and we said for a period of time, and struck up to 90 days because of the concerns that we heard from Dale. Because I don't know, maybe indefinite or limited is a phrase of art.
It's a policy decision. If you
Yeah.
just wrote a period of time, then the court could set any period of time. It could be 2 days,
Scary.
it could be 2 years, that could be a period of time. So, it depends what kind of discretion you want to give the court in making that decision.
The question's really around the 90 days and whether it fits for folks with intellectual disabilities as well as it fits for folks with mental health issues. And I'm gonna ask Stuart, sure, are you here?
I am here, Senator. Good morning.
You sent us some information about this, and I'd like to hear what you have to say about it, because it would be helpful.
Certainly. Thank you. So for those who haven't seen the submissions, I understand it is up on the website, and what it does is it lays out both the clinical and legal concerns that Dale would have to imposing a 90-day expiration, a maximum of 90 days on an initial order of commitment. Now, we're not talking about a concern with a 90-day order of placement in a forensic facility, but we're talking about the idea of a criminal division committing to someone to the commissioner's custody, the court committing someone to the commissioner's custody for only 90 days, before which the department would have to come back and prove that that person is still a person in need of continued custody care and rehabilitation. And the reason for those concerns, as I said, are twofold. It's from a clinical concern and a legal concern. Clinically, unlike individuals with mental illness who may receive involuntary medications, for example, and can have their behaviors regulated in a relatively short period of time, perhaps, people with intellectual disabilities aren't going to be, quote unquote, cured of their intellectual disability with the administration of a medication. We don't administer involuntary medications to individuals as a result of their intellectual disability. And so what we hear from a clinical perspective, and it's in the memo that we submitted, is that it takes quite a period of time for that individual to be stabilized, a period of months, for example. And then there's a process by which the modalities of treatment and what actually will work, and then an opportunity for that individual to implement those tools to actually change their behavior. And so the opinion of our public safety specialist has been that the annual reviews provide the appropriate amount of time for the individual to change their behaviors. If we require the department to come back to the court in 90 days to prove that the person is in need of continued custody care and habilitation, the department actually has to show that since the initial order of commitment, which is no more than 90 days prior, the person has engaged in, has either inflicted or attempted to inflict physical or sexual harm to another, that they've engaged in threats or actions to have placed another person in reasonable fear of physical or sexual harm, or they've exhibited behavior demonstrating that there's a reasonable likelihood that they would inflict or attempt to inflict physical or sexual harm on another person. So if in that 90 days, that person hasn't done any of those things, they happen to be on their best behavior for 90 days, and the department can't prove by a preponderance of the evidence to the court, or is it clear and convincing evidence to the court that the individual is in need of continued custody, the court actually, after that 90 days, would have no choice but to discharge that person from the commissioner's custody. And if they're not restored to competency, they couldn't be tried for that underlying crime and they'd have to be released. So the concern is not only do individuals with intellectual disability, are they likely not to be restored or have their behaviors modified in such a short period of time, but even if we require a showing to the court that they're still in need of continued custody, it's quite likely that the department would not be able to meet that burden because the person didn't exhibit those concerning behaviors in that 90-day window. So that's why we think the 90-day expiration date is problematic. And we currently have orders that are open-ended with an understanding that a person can request a review within 90 days of that order, but it's not mandated. And there's also this annual judicial review process by which the court will look at the commitment and make a determination as to whether that person, after a year, is still in continued need of custody care and habilitation.
Questions?
Would it be possible for you to suggest a time frame or a date that is data-driven and based in best practices so that we could at least have something to work with?
Certainly. So what we provided was a memo from our public safety specialist who works with an individual with clinical background as well, who recommended that a period of time of less than a year is not sufficient amount of time to engage in a review or a requirement that the person's behavior has changed. We fully understand that someone could be reviewed for the appropriateness of their placement in less than a year. So if someone goes into a forensic facility, it would not be inappropriate to have more regular reviews as to whether that placement is appropriate and the least restrictive. But as far as whether that person is in need of custody care and habilitation, the recommendation is that the 1 year mark is the appropriate amount of time. And that's from our clinical perspective. And I think if it's not sufficient what's in our memo, I can try to get some additional data for you on that point.
That's helpful. Question, go ahead.
So where is the annual review? Where does that show up in the?
That's the, somebody needs continued care, custody and habilitation. So it's after the 90 days. If the court orders a a further order of continued treatment, then it's for up to a year.
Okay.
As the 90 days is written here, but if it's a period of time for commitment,
Oh, as written here.
yes.
Under existing law,
Under existing.
it's, both orders are open-ended. There really isn't a continued process right now, but it's an open-ended order, and every year there's an automatic judicial review to see if the person still meets criteria.
And
Okay,
that's in the
so,
family division. And yes, the initial commitment's in the criminal division, then the family division looks at it annually. But the person has a right to request a review after the first 90 days in existing law, even though the department isn't required to come back to demonstrate a need for continued custody after 90 days. An individual does have a right to ask for that review no less than 90 days from the date of that initial order.
okay, what about, I'm still concerned about just having the vague term indefinite or limited period. I think that is super open-ended. So, and the automatic annual reviews, my guess is don't necessarily happen in a super timely manner, and they can get delayed for various reasons. So I still think that we should have a time period for this initial, and I hear you that 90 days is too short, but,
My suggestion would be hold that thought. I mean, it may be something like no less than a year, or no more than a year. I'm trying to sort that out as well, but it's a commitment order. The order of commitment. So let's keep the order of commitment in our heads and then move through the bill and see what is next in terms of,
well, I mean.
I just want to get to the next place.
Okay, but this
we
is
got
a
it. This is a
decision
place.
point.
This is a huge decision point. And we've heard that folks with intellectual disabilities, if you're going to redo the commitment order, 90 days is insufficient for that, in any way for that to happen. They don't receive clinical treatment, medication. In fact, they do receive counseling or other services. So the time period becomes interesting. So let's look and see what the annual piece is all about. Let's keep moving forward on this one.
Okay, I'm just concerned, I don't want people to just be stuck in a forensic facility because we left it so vague as to.
And that is the issue that the working group pondered on tremendously.
I hear that the working group pondered on it, and so.
Wait, let me finish. Some of the legislative language that is here actually improves the process that has been in law, but this is very specific to the forensic facility. So, and to least restrictive place. So I think we need to go through this. We've got a decision point. I agree with you. We all put this in last week. Now let's figure out how we can improve it so it doesn't change the commitment process, so that the individual can be on good behavior and then leave and cause further problems. That's it. It's here. Okay.
Okay.
We have a decision point.
Okay, so just to be clear, this subsection A applies to commitment. It's not specific to placement at a forensic facility. Okay. Subsection B, commitment procedures for an order initially issued pursuant to this section, and for discharge from an order of commitment or continued commitment. This is a cross-reference that all of our processes are governed in Title 18. This is Title 13, where the initial commitment is happening. And subsection C, in accordance with Title 18, if the commissioner seeks to have a person committed pursuant to this section placed in a forensic facility, the commissioner shall provide a statement setting forth the reasons for the commissioner's determination that clinically appropriate treatment and programming can be provided safely only in a forensic facility, including the recommendation of the Human Services Safety Panel. And then we have our cross-reference to the forensic facility.
So first there's commitment, and then there's a determination of the utilization of a forensic facility for that commitment.
Yeah.
Okay,
So first commitment, and then if there's a request to use the forensic facility as the placement, that has to be, there has to be specific information that the commissioner is providing to the court. Okay. So now I'm moving into the subchapter in Title 18, specific to individuals with intellectual disability. We had, in the previous section, we had cross-referenced to all of these processes.
again, I'm gonna go back. Let me go back and let me ask this question regarding C, and I think it may go up to the screen. But, so first we have an order of commitment, so they're committed for a period of time.
Mhm.
And that at the same time, is it at the same time that the order of commitment is requested, put in place, that the individual would be asked to be placed in the forensic facility? Does that occur? Is that concurrent or is it sequential? Or is it silent?
If at the time that the commissioner is seeking to have the person committed, they're determining that the placement, their recommendation is that the best placement is at the forensic facility, and they're giving that information to the court at the time that they're seeking commitment. And then the language we're gonna look at next says, when the court is looking at this and making a decision, the court is first deciding, yes, this person is a person who meets the standard of needing care, custody, and habilitation. Next, I'm going to look at the question as to whether the forensic facility placement is appropriate.
How much time does it take? Do we know that, about how much time it takes the court to make the decision around?
That would be a question for Stuart.
It is a question for Stuart. Stuart, how much time does it take for the courts to make that decision?
Once the hearing is concluded, or from the time that the
Let's go through
individual.
Let's go through the timeline.
Okay.
Both for the recommendation for commitment and then the timeline for the courts to make a determination about whether or not the individual is placed in a forensic facility or other.
Yeah, well, because we don't have the forensic facility now, I can't speak as to how long it would take to make a determination as to which option would be best. I can only speak to generally how the process works from the time the person is found incompetent to the time that a commitment hearing is held, and the court makes the determination as to whether there is a designated program, meaning they can be placed in a community-based setting. So
let's talk about that.
Sure.
Briefly.
Yeah, and I'm sorry, but there's really, unfortunately, no set amount of time, because circumstances, there may be continuances, there may be a need to develop community-based programming, which may take a little bit longer, and then so the court may postpone the commitment hearing for a period of time. There is, or sometimes the case may be resolved by a stipulation of the parties, where the state's attorney, the defense attorney, and the individual and their representative from legal aid may decide that commitment is appropriate, and may stipulate to it, and it won't require a contested hearing. If a contested hearing is held, that could take, once it's started, it could be resolved in one hearing. But then the court might take several days or weeks, perhaps, to issue an order. So that's unfortunately the best estimate that I can give you. It really depends on whether it's by stipulation or contested hearing.
Depends
And
on
if-
also the backup in the courts.
That certainly.
It is troubling. Okay, so, yeah, so, I'm just raising this because if we put a timeline initially, then it might get messed up later on, so.
Well, that's why I don't
Yeah.
trust just leaving it to the 1 year review, because those things always get backed up in the courts. And so it makes it,
We did a lot of good work on that competency piece last year, but it relates more to ability to evaluate over time, so. Okay, so Katie, we're still on this one,
Okay,
yeah. Go ahead.
okay, so we're moving into Title 18. We have a definition section. We usually kind of jump over this, so let's go.
So
through it.
wait, so we left,
We left Title 13. We
okay,
are still addressing individuals with intellectual disability and the process of custody to the Commissioner of Dale.
yeah, so because it's in Title 13, it does very much deal with the process that goes on in the courts, and I may have to, maybe we'll have to get some input from our neighbors in judiciary. The implications of.
Yeah, there are a lot in both parts of the bill. There are a lot of judicial processes, yes,
Okay. So,
on page 20.
we are. So we're adding a definition of commissioner, means the Commissioner of Dale, removing the definition of danger to harm to others. Designated program definition stays the same. We're adding a cross-reference to a forensic facility. Person in need of custody care and rehabilitation has been updated.
Yeah, and this is a little strange construction for a person in need of custody care and rehabilitation means a person with an intellectual disability, which means significantly, so the which means is the intellectual disability. Is there not a definition for intellectual disability somewhere in here?
We added a definition to all of the titles in the Respectful Language Bill 10 years ago. So let me pull that up and see.
IQ 7.
That would have been in Title 1. Am I remembering this right?
Okay.
Yes, Title 1, Section 146. Intellectual disability, a person with an intellectual disability shall mean an individual who has a significantly sub-average intellectual functioning existing concurrently with deficits in adaptive behavior. Intellectual disability replaces what was previously known as mental retardation. That is the definition.
That's here. It's the same definition. It just, the way it means a person with an intellectual disability, which means.
So this applies, what is the,
There's the umbrella.
this should apply to all the titles. I just want to take one more look at this. The construction of all the statutes, so it applies throughout. It applies throughout all the titles.
Yeah, I mean, I just highlighted this as something that I thought was kind of a strange construction of a definition within a definition, sort of nested definitions that are a little clunky.
So because we have the definition in Title 1, we could say it means a person with an intellectual disability. They're not identified. An intellectual disability that manifests before 18 years of age. I'm kind of asking the question if that would be appropriate.
That's the
Are we
only difference
changing the
is
definition of
manifest
intellectual
before.
disability
Yeah.
in Title 1?
No,
No, thank you, okay.
Whereas the conversation is that because the definition in Title 1 applies to all the titles, do we need this language, which means significantly sub-average intellectual functioning existing concurrently with deficits in adaptive behavior in Title 18. And instead just say means a person with intellectual disability, either end it there or say a person with intellectual disability that manifests before 18 years of age. And I don't know which would be more appropriate.
Are you gonna, well, you'd have to reference Title
We don't because, it applies to all of the
I.
titles.
Gotcha.
Or you could, you could absolutely cross-reference it. You could say a person with an intellectual disability as defined in 1 VSA 146.
The only reason I suggest that is, it's sometimes a bit frustrating to see it pop up and then not have a reference.
Sure, yeah. I don't think you need it, but I think you could absolutely add it for clarity. But the question remains, I don't know if you need that manifest before 18 years of age. That's a question for somebody with more expertise.
I mean, other than being a little linguistically clunky, is there anything wrong with wording it like this?
No, you could keep it.
No, I just flagged it as something that was,
Okay, all the
Clunky.
education experts in here.
no,
Okay, no, got it. So the question is about referencing Title I here.
I
we're
don't-
just leaving it the way it is, I guess.
I don't think the
leaving it.
question is, yes, my question is, if you are cross-referencing 1 VSA section 46, do you keep this language manifest before 18 years of age? I'm wondering if Dale might have an opinion or if there might be.
Stuart, do you have an opinion about whether or not manifest before the age of 18 should be left in if we reference Title I?
Well, I actually don't have Title I open in front of me, so am I hearing that there's no reference to the manifest before age 18 in Title I?
Yes, otherwise they're
They're the same.
similar. That would tracks, yeah.
I would be concerned that if that's the definition we're relying on, that may be the one that's utilized, and that would be inconsistent with the DSM definition, which requires that it be manifest before 18. So I think it's important to keep that language in.
Okay, so the question then for us is to reference Title I or leave the definition as it is.
We can leave it as it is. I just was.
Yeah, I think-
The construction is a little,
Okay,
funky. It does, it's.
I agree. Yeah, well, let's leave it.
Leave it as is.
Yeah, all that, but that's good. It helps us understand it there.
Okay. And then in subdivision B, a person who has inflicted or attempted to inflict serious bodily injury to another, or who has committed an act that would constitute sexual conduct with a child or lewd and lascivious conduct with a child, and for whom appropriate custody, care, and rehabilitation can be provided by the commissioner in a designated program. Then we have a new definition of person in need of continued custody, care, and rehabilitation, because this is sort of this concept of continued custody, care, and rehabilitation is a new concept in this bill. So this means a person who has previously found a person in need of custody, care, and rehabilitation, who poses a danger of harm to others, and for whom the commissioner has, in the commissioner's discretion, consented to or approved the continuation of the designated program. A danger of harm to others shall be shown by establishing that in the time since the last order of commitment was issued, the person has inflicted or attempted to inflict physical or sexual harm to another, by the person's threats or actions has placed another person in reasonable fear of physical or sexual harm, or the person has exhibited behavior demonstrating that absent treatment or programming provided by the commissioner, there is a reasonable likelihood that the person would inflict or attempt to inflict physical or sexual harm to another. And then we have our definition of victim, cross-referenced from Title 13.
Oh, that's the other thing. We did hear from one victim's mother, and then we recently received another set of testimony that also has been posted on the webpage from another victim's relative. Okay,
Do you have a comment from Dale if you would like to take it?
oh, thank you, go ahead, Stuart, thank you.
Thank you, Senator. I just wanted to point out that this is the section that I was referencing when I was explaining before about why the 90-day time frame really does not work. Because as you can see here, the department has to show danger of harm, and for continued commitment would have to show that since that initial order, the individual has done one of these things in A, B, or C in order for commitment to be continued. And so if the department couldn't show one of these dangers of harm, then the person, as I said, would have to be discharged from the commissioner's custody at day 90. And it's quite possible that that person may not have engaged in one of these behaviors in the first 90 days. And that's why when we have a 1-year period to look at, it's more comprehensive, and we can determine at that 1 year mark whether that person is still in need of continued custody.
Okay, thank you.
Right, and that's why, I mean, can't we just change the 90 days to up to 1 year? So there's still
Go
a
for it.
period?
The
That's
commitment,
what I was trying to say when we were back there.
all right, well, let's go back there and say
Because
it.
I don't want to leave it indefinite or limited period. I'd rather have a set period in there because I don't know that the
It's
vagueness,
concerning
it's
that you
concerning
leave
to me.
people.
So if we have up to 1 year, then
So-
even though there's a review at 1 year, it would just make sure there's definitely somebody looking at it.
So remember, it's commitment up to 1 year.
Mhm.
So, Stuart, can you comment on the suggestion of, on page 18 of the bill, instead of saying indefinite or limited period, saying, I don't know how Katie would say it, indefinite or limited, up to 1 year?
Yeah, I think, yeah, Dale could support that change. That is the practice, and for a period of no more than 1 year would be fine, something like that. Along with the language that Katie included later in the bill, I think that says that provided that the application for continued custody care and habilitation is filed on or before the expiration, that much like it is now in the mental health world, that order will continue. So if there happens to be a bit of a backlog in the court and we don't get to a hearing on the motion until month 13, that individual isn't automatically discharged from custody on the 12th month. But there is an expectation that the application must have been filed by the expiration of that 12-month period.
The application for
Continued, the motion or the petition for continued custody would have to be filed prior to the expiration of the 1 year initial order.
So, okay, so that resolves that problem back on page 18 with some,
Yes, and I want to put a flag in the fact that because you've made a decision about 1 year for the initial order, in 8845, you need to put language back in about the ability for the person at 90 days to ask for review. Because when the change was made to go to 90 days, that didn't make sense. So I'm gonna mark that as a note for myself to make a corresponding change there.
yes,
90 days.
Yeah. that's 8845.
Yeah.
Okay.
So
We're gonna spend about 7 more minutes on this, and then we're going to, we've got folks, I think there's some students coming in, so we'll do that.
Okay.
Get to what we can get to.
So the next 3 sections are sections that are removed. 4 sections are sections removed from the bill, and this is language that made sense if there were with corresponding language from another subchapter that had been previously repealed. So that is why that language has been removed. We have language about legal competence, and the change here is to add in individuals in need of continued custody care and habilitation. So no determination that a person is in need of custody care and habilitation or in need of continued custody care and habilitation, and no order authorizing commitment shall lead to a presumption of legal incompetence. So we're just adding in the second group under second order. And then we get to 8845, and this is our initial order for custody care and habilitation. Even though this process starts in Title 13, Criminal Division, we're cross-referencing to Title 18 where all of our process lives for this population. So if a person is found incompetent to stand trial, the Criminal Division of the Superior Court shall automatically schedule a hearing to determine whether the person is a person in need of custody care and habilitation and requiring commitment. Something Stuart said raised a question for me, which maybe we don't have to address, but the stipulation, do we have to say something if not otherwise stipulated shall automatically schedule a hearing? I don't know, but I'll put that question out there.
Where would that go, Katie?
In this first paragraph,
Oh.
1A,
Uh-huh.
I don't know if we need it. That would be a question for others, but I heard him say that sometimes the cases are stipulated. This is saying that we're automatically scheduling a hearing, but I would understand that there are situations where there's been a stipulation and there's no need to automatically schedule a hearing. So, I will need to get an answer on that.
Right, that's something we can't clarify for you.
Okay.
Yeah.
And subdivision A2. Oh, I'm sorry. In A2, the commissioner's recommendation that a person be placed in a forensic facility, if applicable, shall be filed with the court in advance of the commitment hearing. And it shall expressly state the reasons for the commissioner's determination that clinically appropriate treatment and programming shall be provided safely only in a forensic facility, include the recommendation of the panel.
So it is synchronous, okay.
I mean, in theory, the petition to have the person in custody could be filed first, but this recommendation about a forensic facility has to be filed before the hearing actually happens.
Yeah.
Subsection B, the commissioner or designee shall attend to the commitment hearing for custody care and habilitation and be available to testify. All persons to whom notice is given may attend to the commitment hearing and testify, except when the court may exclude those persons not necessary to the conduct of the hearing. And then in C, the Vermont Rules of Evidence shall apply in all judicial proceedings brought under this subchapter. In D, if this is our order, so if the court finds by clear and convincing evidence that a person is a person in need of custody care and habilitation, the court shall order the person to be committed to the commissioner and to receive appropriate treatment and programming in a designated program that provides the least restrictive environment consistent with the person's needs for up to 90 days. So you've just made the decision to change that for up to 1 year. And then in E, if the commissioner has recommended to the court that the person be placed in the forensic facility, the court, after determining that the person is a person in need of custody care and habilitation, shall determine whether placement in a forensic facility is both appropriate and the least restrictive setting necessary to meet the person's needs. If so determined, the court shall order the person placed in a forensic facility for a term not to exceed the duration of the initial commitment order.
So what I'm gonna suggest, we're coming back to this tomorrow morning at 10 o'clock. So I'm gonna suggest that we end here, this is a good place to end. And then, because we have some students coming in to share with us who they are and what they're here for. So let's do that. And then 197, and we were somewhat optimistic at 197 and 187. What we'll do is we'll put those on another day with apologies to you folks who are here for that. But this has really been a good chunk of time for our committee to go through a very difficult, process and bill. So we'll put a hold on this right now, and then we'll invite the students in, and we'll pick this up tomorrow morning at 10 o'clock. I think that's what's scheduled. Thank you, Katie.
You're welcome.
This whole issue is not an easy one. And thank you all for your work on the bill. It's really great to have everyone asking such terrific questions. Really amazing.
This is really heating up. In the last hour, I've received 25 emails.
Yeah. Is that what all the
Not
holidays
the
are
same
going to come out?
people. I've
I
had
know.
emails from a bunch of the same people.
Oh,
But I'm
nice.
surprised at the corporate engagement.
Sorry?
I'm surprised at the corporate engagement.
Oh, wow.
Oh,
Yeah,
yeah.
big bucks, big bucks.
Big bucks. Oh. Come on in. Well, we'll leave the door open so that we're not over capacity. And you can just sort of fill up the doorway. That's awesome. Come on in. Welcome.
They all from the same place?
I don't think so. We're gonna find out. This is great. Come on in. Right over. Yeah. Good to see you all. I think I saw you outside.
Yes.
Now you're warm. That's great. Thank you for being here. So I'm gonna have the committee introduce themselves, and then you're gonna introduce yourself really fast with the name of school that you represent, who you are in your school. And so we'll start over here.
Hi, everybody. I'm Martine LaRoque-Ulick. I live in Burlington. Nice to see you today.
Good morning, you guys. I'm Senator David Weeks from the Rutland County, and I live in Proctor.
Senator Ginny Lyons representing Chittenden Southeast, which is a whole lot of towns in Burlington County. A little bit of Burlington.
Senator Terry Williams from Rutland County, from Fulton.
Hi, everybody. I'm Senator Ruth Hardy, and I represent the Addison District and live in East Middlebury.
So first question is, are any of you from any of our districts? Raise your hand if you're from any of our districts. Not. What a shame. Wait, you gotta move. This means you have to move. I saw Lamoille. How many of you from Lamoille? All right, how about Franklin County?
Well, we're all from Lamoille.
We're all from Lamoille County. Oh, well, that's a good place to be. So, do you have something you'd like to share with us? Anyone? Go ahead. Say your name and then share briefly.
Good morning. My name is Alma Green. I'm here with Addie Stutz and Liana Harvey, and we are I'm in 8th grade at People's Academy in middle level, and we are members of VCAP, the Vermont Kids Against Tobacco. Okay. In my first year in VCAP, we asked PA high school students to share their stories with us about vaping.
Yeah, can you come in and close the door because it's loud out there?
Thank you guys. They're noisy out there. Thank you.
Okay. In my first year in VCAP, we asked PA high school students to share their stories with us about vaping. We wanted to present these stories to the middle school students. Middle schoolers look up to high schoolers. Sometimes we hear messages from older students better than we hear those same messages from our teachers or other adults. We would like to read some quotes from this anti-vape campaign. I'll start and end with the positive.
The first is from a People's Academy junior. I've been asked to vape a few times. I always say, no thanks, I'm an athlete, I'm all set. My friends are good with that answer.
From a PS sophomore, it is hard for me to take deep breaths sometimes. I've developed a cough that is really annoying. I get very anxious if I don't have nicotine. I have also lost weight as a result, and my hair has started to fall out.
From another sophomore, I can go for more than an hour without feeling the need to vape. If I went an hour without vaping, I felt like I couldn't breathe. I would get anxious and begin to feel angry.
From a senior, You might think it's cool to try vaping, but in a year or two, it'll control your life. After vaping for 4 years and quitting one time, and then going back to vaping, I can tell you it's not worth it, because stopping after starting is hard.
And one more from the PA senior. I quit the vape. I feel better about myself. My lungs feel better. I'm less anxious. I feel more in control of my time and my life.
We hope that you remember these very real words from some of our high school students. All of these students were initially attracted to the vapes because of the flavors. Blue raspberry was a favorite. It was the flavors that hooked them. As time went on, the flavors didn't really matter. They vaped because they were addicted to nicotine.
Thank you for listening.
Thank you for being here. Thank you for sharing.
Wow.
That's terrific. So what I'm gonna say is there are a few more folks who just came in. I'm gonna ask you, are you from, Chittenden County?
Yeah.
Yes? Yay! Cool. Thank heaven. We didn't have anybody in here really. Heinsberg. Oh,
Nice.
That's my district. That's awesome.
What grade are you in? Sixth grade?
Do you wanna, we have a couple minutes. Do you wanna just share with us, what you brought? It'd be terrific. Go right ahead. So just say your name and then read,
Alrighty. My name is Joe. I'm in sixth grade at Heinsberg Community School. I am here to address the issues of flavored vapes at school. We recently had to install a vape detector in the 5th through 8th grade girls' bathroom because we were having an issue with students vaping during school hours. Rather than sending them to the principal's office to be suspended or punished, we treated these students as if they were in medical danger and set up a way for them to get off their addiction or figure out the root of why they got addicted. Using vapes as a child in school can affect your work or your mental space you're taking in vital information. Vaping can also increase your anxiety or increase the likelihood of diagnosed depression. As someone who loves to sing, I can't imagine doing anything that would affect my voice. I hope you consider saying yes on S18.
Hi, my name is Lynn, and I'm from community school. I'm here to tell you what Reese's Sparks flavors back is. Now, I know what flavors are, I'm sure a lot of you do too. But if you don't, it's what they put in vapes to make the tobacco taste good. And when I looked up what was in the vape flavor, it said carbon chemicals used in it. That should be enough to tell somebody that this needs to be banned, because really chemicals, they're not even trying to hide what they're doing. They're definitely targeting kids, because why would they wait? There's no way to say that they're targeting tobacco companies, because that's exactly what they're doing. Why would we pretend that tobacco companies are not trying to do this into getting addicted to nicotine? Because of course they are. There are a lot of customers 70 years plus. Also, in a vape alone, there's lead, nickel, tin, and arsenic. I could go on. Do you know how dangerous those metals are? Some of those metals alone could kill. For tobacco companies, it's not about humanity, it's about money. If we ban flavors, we don't have to worry about this, because vaping won't be interesting, because it won't taste good. Then there won't be a reason to. If people are saying, what about adults? Adults should be able to choose if they want flavors or not. But here's the problem. That's all right now, and it's not working. Kids still have access to flavors. The only option is to ban them entirely.
Hi, I'm Luna. I'm a sixth grader at Heinsberg Community School and a member of the CAT, Vermont Kids Against Tobacco Group. I recently attended the Vermont House Youth Leadership Summer, and I learned about leadership and advocacy. I am helping to educate my classmates about the dangers of nicotine and vaping so we can be healthy and tobacco companies don't trick us. I don't like how tobacco companies are targeting youth kids by using flavors. I don't like not feeling safe because tobacco and nicotine products are now in our schools. We need your help. I passed an S18 bill that will help many kids who are addicted to vapes by getting sucked in with addictive flavors. When Bill S18 goes to the Vermont legislative vote yes on the S18 to end this all flavored vape products in Vermont and help keep kids safe. Thank you for listening to youth.
Wow, thank you. Terrific. Terrific. Thank you all for being here. Oh, this is great. Thank you. And enjoy the rest of your day. And just so you know, this committee actually voted S18 out. We're waiting for the House to send it back to us so we can send it on its way to the governor. So we appreciate all the work that you do and the time that you've taken to be here with us. And how many of you walked down the hill this morning? Good work. Do you have to walk back up the hill? Good.
Down
They
what
walked
hill?
from the
From-
Fine Arts College
Oh.
down. They had a parade. It was awesome. It was terrific. Thank you all.
Thank you very much.
Well, that's a wrap.